Hello and welcome to Absolute Trust Talk. This is another Facebook Live version of our podcast here at Absolute Trust Counsel. I'm Kirsten Howe, your host, and today is going to be a different kind of episode because I don't have a guest. It's just going to be me. It'll be a little shorter. And the other thing is we're kind of going out of order. Ordinarily, we do the live versions on Thursdays, but this is a Tuesday. And the reason for that is my topic is very timely. It's very time sensitive, and I didn't want to wait till Thursday to talk about it. I'm going to be talking about Prop 19 and what you need to know and what you might want to do about Prop 19. I sent an email out a while back to my clients, letting them know about Prop 19 and the issues that might affect them. And I got such a big response that I figured I really need to reach out to more people, make sure everybody knows about Prop 19 and doesn't overlook some opportunity, some planning opportunity. So we're going to be talking about those planning opportunities and what you might want to do with respect to Prop 19 in just a minute. First, as regular viewers know, we have to do a little bit of housekeeping. We are recording this episode as always, and so it will be a video available on our website, absolutetrustcounsel.com, in a few days, and it will also be a podcast episode, just an audio version of our conversation here today, will be available as a podcast, also on our website, absolutetrustcounsel.com, and also wherever you find your podcasts. So give us a few days, that'll all be up and running. The second thing is, as always with the live versions, we do take questions. So if, as you're sitting here listening, you have a question, go ahead and type it in the comment area on Facebook. And at the end of my presentation, I will answer your questions. If you are listening to a recorded version of this, you can't ask a question, I'm sorry, but I will answer the questions that I get. Okay, so here we go. We're talking about Prop 19, and in order for you to understand what I'm talking about, I have to give you a little lesson, a little background in California property tax law. And I'm sorry about that, but just bear with me. Once you get through all of that, you'll understand Prop 19 a lot better. In California, when we own real estate, as in, I'm sure, every other state, we pay taxes on that real estate. And in California, our tax is based on the assessed value of the property. Whatever the assessed value of the property is, the tax that we pay every year is approximately 1% of that. Now, that's not exactly true because every county and some cities tack little extra taxes on there, but the basic tax is 1% of your assessed value. Now, what is the assessed value? The assessed value, generally speaking, is the price that you paid for the property when you first acquired it, plus any increases that take place over the years in that assessed value. So here's my example. I'm going to tell you. So I bought a home in Oakland. That's where I live. Let's pretend I paid $100,000 for it many years ago. That's not true, but it's easy math. So I paid $100,000. So in that first year that I owned my home, my property tax would have been $1,000, which is 1% of $100,000. Subject to Alameda County and Oakland tacking on some extra little taxes, but the basic tax would have been $1,000. Okay, so then as time goes by, every year the assessor, the county official who's in charge of assessing property, gets to increase that value based on what they think the property is actually worth. So back in the 70s, people's assessed values were increasing dramatically based on the fact that California real estate was increasing in value dramatically. But that's a value that you don't appreciate. You're just living in your home. So what if it's worth, $50,000 more than you paid for it. You're not seeing that $50,000. It's so people were upset that their property taxes were going up so quickly. It made it hard for people, especially people, in retirement who have a fixed income, made it hard for people to continue paying their taxes every year because the value of their property was going up. So many years ago, as everybody who lives in California knows, the voters of California passed Prop 13, which is a ballot initiative that led to a constitutional amendment. And Prop 13 said, you assessors, you don't get to raise our property taxes like that. You only get to increase our assessed value at most 2% every year. So in my case, my hypothetical $100,000 Oakland home, even if my home increased in value from the first year to the second year by $10,000, the assessor could only increase my assessed value by $2,000, which is 2% of my assessed value. So that was a good thing for the taxpayers, for the property owners. They were guaranteed that their property taxes would increase just incrementally every year, not dramatically every year. And so it enabled people to stay in their homes, to hold on to their homes, even when their incomes weren't increasing dramatically every year. They were on a fixed income. So that was a good thing. People were happy with that. And property taxes under Prop 13 are kind of like rent control. That's the analogy that I think of. So, under rent control, the landlord and the tenant, they agree what the rent's going to be, and then the tenant moves in, and that's what the tenant pays. And then under rent control, if you live in a rent control jurisdiction, the landlord only gets to increase the rent by a certain percentage every year, no matter what people are willing to pay on the free market. If you have a tenant living in your place, you only get to increase it by a certain percentage every year. So it's the same under Prop 13. If you live in your house, as long as you keep living there, they only get to increase it a certain percentage every year, 2% at most. Okay, so, but like rent control, if you sell your house to somebody else, then the assessor gets a reset. They get to charge the assessed value is going to go up to a fair market value, and they get to start all over again and charge higher property taxes, right? So it's just like rent control. Whenever the property changes hands, there's a reset on the property taxes. So a few years after Prop 13 was passed, the voters of California passed another initiative called Prop 58. And what Prop 58 says is, you don't get a reset, Mr. Assessor, when the property transfers between a parent and a child. So if a parent dies and leaves their property to a child, if a parent sells the property to a child, or a parent just gives the property to a child, the child gets that same low property tax that the parent has been paying. So there is no reset between parent and child. And there are a few little exceptions to that, little qualifications to that. I'm not going to go into that right now because I don't want to bore you to death. Just understand that what Prop 58 added was that parent-child exclusion from reassessment. And that also was a good thing if you own real estate and you wanted your kids to be able to own it too after you passed away and have your same low property taxes. That was a good thing. That was Prop 58. So now, in November, the California voters passed another ballot initiative, and it's called Prop 19, and that's what we're talking about today. And Prop 19 got rid of almost all of Prop 58. Prop 58, remember, was the parent-child exception. Now, under Prop 19, which will be effective February 16th, just about a month from now, under Prop 19, the only time a parent-to-child transfer will let the child keep those low property taxes is when the parent transfers their primary residence to a child who also keeps it as the child's primary residence. So primary residence to primary residence, you can keep that low property tax that the parent has been paying. And there are even exceptions to that, which again, I'm not going to go into. But you can imagine that that's a big change, because I look at a lot of my clients own rental properties, and they would really like their children to inherit their rental properties and keep that low property tax. But under Prop 19, that won't happen. Under Prop 19, the assessor will get a reset on rental properties. A lot of my clients own vacation homes, and these vacation homes have been in the family for many years, and they would love for their children and grandchildren to own those vacation homes. But under Prop 19, the vacation home is going to get a reset, and the property taxes will go up. So let me give you an example of a case that I'm actually working on right now, where we are going to actually do something to help the family. So this will help it make a little bit of sense to you. My clients, the parents, bought a family vacation home up at Tahoe many years ago. And right now, their property taxes are $3,700 a year. $3,700 a year. If the parents were to transfer that vacation home to their children right now, before Prop 19 becomes effective, the children's property taxes would also be $3,700 a year, and the assessor would be able to increase it just 2% every year at most. However, if the parents don't transfer it to their children and they just wait until after February 16th and then they die, the children will inherit the vacation home, but their property taxes will be more than $19,000 a year, because this home is worth $1.5 million. It has really gone up tremendously in value, and the kids will have to pay property tax based on that really high value. Now, $19,000 is a lot of money to pay for a vacation home every year. Plus, you got to pay for insurance, you got to pay for upkeep, you got to pay to heat it, you got to pay to clean it, all that stuff. So you can imagine that this could make it very difficult and unattractive for the kids, and that's not what the parents want. The parents want the children to have the vacation home. So, and we have clients who have rental properties, and rental properties are not going to be covered under Prop 19. They're going to get reassessed too. So these are the kinds of situations that our clients have been asking us about, and asking, what should we do? Should we transfer our property now? We don't know what to do, and they're asking. And so, whenever somebody asks me a question like that, of course I say, it depends. The problem with all of this is it's not just about property taxes. There's so much else we have to keep in mind. There's capital gains tax, there's estate tax, there's gift tax, income tax, rent control. There's rental income. If the property that you're talking about transferring to your kids now is a rental property and you need that rental income that's paying your retirement, you have to think about that. Does it make sense to transfer now? We have to have a conversation that includes all of those issues. And if you transfer a property to a child now, how are you going to make it fair to the other children? So we got to talk about estate planning. So there's just a lot of issues that have to be discussed. So here's what we've been doing. We are doing what we call a Prop 19 analysis for our clients and other people who want to go down this path with us. What happens when you decide you want to do a Prop 19 analysis? We send you a worksheet so we can collect all the information we need. You send us your trust, you send us your property tax bills, and we do a full analysis. We look at all the tax implications, and then we have a meeting with you and we talk about what could happen if you do something now, what could happen if you wait, what are your options for doing something now, because there might be a few different ways to go, and it's just important to look at it. And we've had clients who do the analysis, and in the end say, you know what, I think it doesn't make any sense for us to transfer the property now. If Prop 19 comes into effect, we're fine with that result. And then we've got clients like the family that I told you about with the vacation home in Tahoe. Yeah, it makes a lot of sense to do it because they would be leaving a lot of money on the table if they didn't do it. All right, so what my point is, there's a lot to consider. And I'm just bringing this to your attention. You need to, if you think this might apply to you, you need to do an analysis, whether it's with us, whether it's with your accountant, but you need to get going on taking a look at it. And I have two very important things to say about that. First is, none of this matters if your children don't want that property. So, who cares about the taxes? If the children don't want the property, don't worry about it. Don't worry about Prop 19. Your family will be fine under Prop 19. So my point is, talk to your children and make sure you know what's important to them. If you have your vacation home that all the kids live on the East Coast and they're never going to go to Lake Tahoe for vacations, as soon as you die, they're going to sell it, then don't worry about it. It only makes sense if your children want the property and they're going to keep it for some period of time. The second thing, really important, Prop 19 is effective February 16th. What that means is if you're going to do anything, we have to get all the transferring done before February 16th. And oh, by the way, that's President's Weekend. That's the day after President's Weekend. So really, we've got to get it done a few days before February 16th. So keep those two things in mind. If this is something that interests you, you think you might want us to help you with it, you can go to our website, absolutetrustcounsel.com, get that Prop 19 analysis going. We have a landing page just for Prop 19. It's absolutetrustcounsel.com/Prop 19. I know, very creative. You can go there, you can read a little bit more about it, and you can also schedule this analysis. We're charging just $500 to do all of that analysis. It takes a lot more time than $500 worth, but I just think it's so important that people take a look at this and satisfy themselves. Either, yes, we're going to move forward and do something, or no, we don't need to, we're fine. Okay, that's my presentation. So now I'm going to look over at the questions and see what we got. Let's see. Make sure I go all the way back to the beginning. Okay. What if a trust says, I leave everything to my, oops. Oh, sorry about that. I leave everything to my 3 children after I die. Will the property taxes on the home go up after the parent dies? Okay, so that's a pretty basic question. And the answer is, of course, it depends. But remember, after February 16th, if you don't die before February 16th, and really we don't have much control over that, if you die after February 16th, the only situation where the property taxes won't go up is if your primary residence is left to a child who makes it his or her primary residence. In every other case, vacation home, rental property, or if the children don't make it the primary residence. Sometimes children inherit the parent's home and they turn it into a rental property. That's not gonna fly. The taxes will go up. So it really depends on your individual situation, and I encourage you to talk to a professional about that. Okay, here we have from Laura Breisky. Single parent lives in primary residence. Assessed value is $250,000. Fair market value is $1,250,000. Parent has 2 children. In estate planning, parent wishes both children to inherit the residence equally. Neither child plans to live in this residence. Parent also wishes to avoid reassessment upon his death in case children wish to hold the residence as a rental. What are possible strategies? Well, it's a primary residence, so I don't like to talk to people about transferring their primary residence while they're alive and living in it. But this is a situation where even if one child decided to turn it into a primary residence, there might be a reassessment because of the difference in the value. Then we didn't talk about that, but only a certain amount of the parent's assessed value can be preserved. If it gets too big, if the difference between the assessed value and the fair market value gets too big, there will be a partial reassessment. The strategy would be transfer it now, transfer it to the children now, possibly in an irrevocable trust, so that the parent can still have a little bit of control, and you get the Prop 19 transfer benefit now, and then later when the parent dies, they can turn it into a rental property. That's just my sort of off the cuff reaction to your question. Again, I encourage you to talk to a professional who can look at the exact issues that you have in your family. Okay, if real estate has already been transferred to a revocable living trust and the children are the beneficiaries of that trust when the parents die, will the children get to keep the low property taxes when the parents die? The answer is no, unless the parents die before February 16th. Transferring property to your revocable living trust, even though your children eventually will be the beneficiaries of that trust, is not a transfer to your children. And remember, it's only the parent-child transfer that gets us an exception from the reassessment. So transferring your property into your own revocable living trust, you have not changed ownership of the property. So that's still about to happen at some point. Okay. If a vacation home is owned by a bypass trust created when the first spouse dies, what will happen when the second spouse dies? Okay, so again, that's property that would be transferring from parent to child when the second spouse dies. And if that happens after February 16th, there's going to be a reassessment unless it's the primary residence being transferred as a primary residence to a child. Most primary residences are not owned by bypass trusts, so I'm guessing from this question that that's not what we're talking about. So if that's true, my answer is for sure it's going to be reassessed unless the surviving spouse parent dies before February 16th. Okay, Dean Cook asks, if two siblings inherit a parent's primary residence, can reassessment be avoided if only one of the siblings moves into the home? The home has to be owned by the sibling who moves into the home and calls it his or her primary residence. You cannot have a sibling co-owner, is my understanding under Prop 19. So one of the siblings would have to own the home. Maybe the other sibling would get stock and cash of equal value. That's an estate planning issue. You're going to have to talk to your estate planning attorney and see if there's a way to make that happen. Denise asks, if parent sells their primary residence to child before February 16th to preserve Prop 13 value, can the parent still use Prop 60/90 to transfer their tax base to a new primary residence? I'm not sure about how those two work together. I'm not sure that you get to have the low tax base left behind for your children and also take the low tax base with you. My suspicion is that you don't. I think that under existing law, you don't get to double dip like that. I'm not 100% sure about that. So what Denise is talking about is under Prop 19 and Prop 60 and 90, when you sell your low property tax base and move to another home under certain circumstances, if you're over the age of 55, you get to bring your property tax with you. So I'm thinking that if you bring it with you, your kids don't also get it. But I'm not sure about that. And one of the problems with Prop 19 is we just don't really know a whole lot about what the law actually is. The Prop 19 was not written by the legislature. It was written by an advocacy group who, on behalf of basically realtors, and there's not a lot, it's not really fleshed out. We don't have statutes, we don't have regulations, we don't have explanation from the Board of Equalization about how this is actually going to work. So I apologize for not really knowing the answer to that question. That's just my sense, is it probably isn't going to be possible to have your cake and eat it too in that situation. Stephanie, do you know what happens to cases that are in progress right now? Prop 58 requests for waiver for reassessment for primary residence and on rental property were submitted in October 2020. County says it takes 8 to 10 months to hear back. Okay, so is it the date of submission that matters, or when reviewed, etc.? Again, we don't really know for sure. However, what I will say is that I believe under current law, it's the date of transfer, and that would be also the same under Prop 19. I don't imagine there's a reason to change that. And what I mean by that is if you signed a deed in October 2020 transferring the property, and you sent it off to be recorded, and you sent your parent-child exclusion form to the assessor's office, that's a transaction that's already done, and Prop 19 should not apply to you. Under current law, the transfer, when a child inherits property from a parent, the transfer occurs on the day the parent died. So whether or not you get around to actually writing a deed shouldn't matter. What I would say is that if you are in that situation where you inherited property from your parent, but you haven't yet done the deed, I would hurry up and do it anyway, and just make sure that you get all the documentation done before February 16th. It shouldn't matter, but we just don't know. Okay, Jeff asks, so time is of the essence. Yes. Do you think this will compel investors to sell their rental property sooner than later when the heirs' property taxes get reassessed to current market value? That is the $64,000 question. That's what people think is the motivation behind the passage of Prop 19. Is it was an attempt to incentivize people to put their properties on the market, so there would be more real estate changing hands. Because if you can imagine, if you inherit a rental property from a parent, and the parent was going along with this rental property making $15,000, $20,000 a year profit, and all of a sudden the property taxes go up $15,000 a year, there's no profit left. So why would a kid keep a rental property that doesn't make a profit? They're going to sell it. And that's just what the law kind of causes. So your question is a very good one, Jeff, and I think you're right. Denise asks, is there a way to transfer rental properties into an LLC or limited partnership to preserve the assessed tax base? The answer is yes, to a degree. There, that can happen. It's got to be done very, very carefully with an attorney involved. So don't do this at home. Consult with a professional. That's one possible solution. It's not a 100%. It's not a home run solution. It's a partial solution. And I encourage you, again, to talk to a professional. Okay, good questions, all of those. Thank you so much for your questions. I am so glad you joined us today. I'm just going to remind you, if doing this kind of planning seems important to you, go ahead, go to our website, absolutetrustcounsel.com/prop19, and you can find out more about that. And I'm glad you joined us. I look forward to connecting with you next time.